Myself, Dr. A.N.V. Durgantuma, Assistant Professor, Department of Commerce, PB Siddhartha College of Arts and Science. So today my topic is essentials of valid contract. Before discussing about essentials of a valid contract, we should know the meaning of certain terms, agreement and contract. So, definition of agreement. According to Section 2, subsection E of the Indian Contract Act 1872, defines agreement as every promise and every set of promises forming consideration for each other is an agreement. That means in an agreement, there will be a single promise or set of promises. But whoever the parties involved in that agreement should have consideration for each other. So that is known as an agreement. Coming to definition of contract, according to Section 2, subsection H of the Indian Contract Act 1872 defines contract as an agreement enforceable by law is a contract. That means an agreement, when it be enforceable by law, then it will convert into as a contract. So coming to essentials of a valid contract, so these are the various essential elements or conditions to be fulfilled in order to become a valid contract. If any of these conditions are not fulfilled, that won't turn into a contract. Just they can remain as a agreement itself. So that we can discuss one by one point. So first one is two parties. In order to constitute a contract, there must be at least two parties in the contract, because one single person cannot enter into a contract with himself. Next one, unity of minds. So both the parties must have same intention about the content of the contract. So they should think about the contract in a same way, in a similar way. So coming to next one, legal offer and acceptance. So there must be an offer from one person and its acceptance or rejection may be from another party. So first the offer will be moved from one party and the other party may accept. So the person who is accepting the offer must accept it absolutely. That means exactly as it is and unconditionally, without mentioning any conditions. And both the offer and the acceptance should satisfy all the essentials. Next one, intention to create legal relationship. So the parties, both the parties must have intention to create legal relationship. So if there is no such intention between the parties, then such type of agreements will not convert into a valid contract. That means, for example, if your father promises to purchase a bike or something when you score more marks, but if he fails to do so, can you able to sue your father in the court? No, because you don't have that intention, because this relationship is completely purely social and domestic relationship, which is between wife and husband, or father and son and mother and daughter. So that it's purely family relationship. So there is no such intention. So, but in order to constitute as a contract, there must be clear intention to create legal relationship between them. Then only it is a valid contract. So next one, lawful consideration. Consideration means something in return. The parties, whoever involved in the contract, both the parties should get something in return. So that something in return may be in form of a favor, or in form of goods, or in form of cash, whatever it may be. And that something in return may be past consideration, present consideration, or future consideration, whatever it may be. So coming to competence or capacity of the parties. The parties who are entering into a contract, both the parties should have capacity to enter into contract. So according to Section 11 of the Indian Contract Act, specifies certain conditions about the competency of the parties. So first of all, The first condition is the parties who are entering into contract should attain the age of majority. In normal cases, it is 18. And in case if the guardian is appointed by court, then in such cases, the person should acquire 21 years of uh, age to attain majority. And he must be a person of sound mind. So his mental condition should be stable. He has a sound mind because he must be in a position to take decision whether it is a good for his transaction, good for his business or not. And parties must not be disqualified from contracting by any law to which he is subject. So when the parties satisfies these conditions, so that they are competent or they are capable to enter into contracts. Free consent. The parties must enter into an agreement with free consent. That means with their own wish, without any pressure such as coercion, undue influence, fraud, mistake, and misrepresentation. So, in order to call there is free consent means that means it should be free from these things. Coercion means physical threatening. Physical threatening to do certain harms to physically or to their properties or something. Undue influence. So one in superior position and one in subordinate position. Because of his superiority position, he can dominate the subordinates. Fraud. Intentional misrepresentation. So mistake. So it is unintentional. It is nothing but lack of proper knowledge. So consent will be deemed to be free only if these elements are not present there. So lawful object, next essential element is lawful object. The purpose of the contract for which we are entering, for which the parties are entering, must be lawful object. The purpose must be lawful. So it can be said the purpose will be unlawful when it is forbidden by law, or it, if permitted, it would defeat the provisions of any law, or if it is fraudulent, or if it injures, if it makes any injury to the person or property, or the court regards it as a immoral or opposite to the public policy. So, in such cases, we can say that the purpose of the contract is unlawful. So, it should not be like that. It should be lawful. The purpose should be lawful. So, next one, certainty of meaning. The terms and conditions of the contract must be clear. So, whatever the terms and conditions we want to say, specify to the other party, we should make the same sense. We should clearly mention them. So the clarity of terms and conditions is very much required. If it is not present in the agreement, so it won't turns into a valid contract. Next one, plausibility of performance. So for whatever the purpose we are entering into the contract, the purpose, the objective of the contract will be possible to perform. In case, that means when we enter into contracts which are impossible to perform, so in the starting stage itself, it is not possible. That means such type of agreements won't turn into contracts. Legal formalities. So according to the Indian Contract Act 1872, so for certain contracts, it is enough even though they are in oral. But certain contracts, it is must, they should be in written. But most extent, it is advisable that the contracts must always be in written, because it will be easier to prove in the court in case of disputes arises between the parties or in future also. And for certain contracts, there must be presence of witness also is required. And for certain legal formalities involves registrations and something. So, most extent, there should be written document, it should be registered, and whatever the legal formalities required, all the legal formalities should be compiled. Then only such agreements will convert into contracts. So, not declare it to be void. The Indian Contract Act specifies, declares some of the agreements to be void. That means void means they are not valid, they are cancelled. So, our agreement should not fall under this category. So, examples, unlawful agreements, that means we are doing unlawful activities. Agreements without consideration. So, even though we discussed about this point, lawful consideration, both parties should have consideration. But agreements without consideration, it won't convert into contract. One person is getting consideration and some other person is not getting consideration. No, such type of agreements are not allowed. So agreements must have consideration, but not declare it. So agreements without consideration, agreements to do impossible acts, agreements in restraint of trade. So such type of agreements are specifically declared as void agreements. So whatever the agreement we are entering, it should not fall under this category. So this is about essentials of valid contract. Thank you.